Great. Okay, I think we'll kick off. Welcome everyone to this Garden Core Housing Team seminar. Thank you very much for coming, and we're delighted that so many of you were able to join us. My name is Tessa Buchanan. I'm a barrister at Garden Court, and the topic today is homelessness and suitability. I'm just going to run through a few housekeeping issues first before introducing the speakers. I can just see a message saying I can't hear anything. So if you need technological assistance, you could put that in the chat, and one of our team will hopefully be able to help you out. So everyone has been placed on mute. Resources relating to the seminar will be circulated to registered delegates after the webinar. The webinar is being recorded, so that means that the audio and the video of the panelists and anybody who speaks, if you're unmuted, will be recorded, and the webinar might be then shared on our marketing channels and website and social media afterwards. If you are having technical difficulties, then, as I said, please look at the instructions in the chat window. If you have questions, and we welcome questions, then please put them in the Q&A window. The chat function is meant to be for sort of other comments and queries or feedback. So please kind of try and avoid putting questions there if you can, but don't worry if you forget. When it comes to questions, what we're going to try and do is unmute you for you to ask your own question. And if that does happen, then you'll be recorded when you ask your question. But if you don't want to do that, or if that doesn't work for some reason, then I'll just ask the questions as they come in, and we'll deal with that at the end of both presentations. So we're delighted to be joined by two really fantastic speakers. Firstly, Matt Ahluwalia. He worked at the AIR Centre and at welfare rights charity EWCA and also the Public Law Project before coming to Garden Court. He specialises in social welfare and public law, with a particular expertise in housing, homelessness and migrant rights. And he's very well placed to speak to us this evening because he was junior counsel to Ed Fitzpatrick in the case of Patel and Hackney, which, as many of you will know, is an important recent case on intentional homelessness and affordability. He'll be discussing that with us today. And then we have Connor Johnston, who specialises in housing, homelessness, asylum support and community care. He is a co-author of Housing Allocation and Homelessness. And just as a quick plug, the 6th edition of that is coming out very soon. And he's acted in many of the most important recent cases on homelessness, including Elkundi in Brighton, which was the Everyone In case, Al Ahmed and Tower Hamlets, which was the case on late Section 204 appeals, and Samuels in Birmingham on intentional homelessness. So without further ado, then, I will hand over to Matt, who will be sharing his screen and giving us the first presentation. Thanks, Matt.
Thanks very much. Hopefully that's come up. I'm going to be mainly talking about developments in affordability within the context of suitability this evening. And the reason why I think it's useful just to keep affordability in mind is that it's really relevant to quite a lot of issues in homelessness, not just whether somebody is homeless in the first place or intentional homelessness, but also suitability more broadly, and more recently in the development of reasonable steps to prevent or relieve homelessness as part of local authorities' duties following the Homelessness Reduction Act. And so what I'm going to try and do is give you a short overview of where we are in terms of affordability, and talk a bit about Samuels and Patel and Hackney in particular. Just as a reminder, the main sort of framework in terms of matters that local authorities are going to be taking into account is to be found in the Homelessness Suitability of Accommodation Order. And in particular, Article 2 gives non-exhaustive examples of certain things that need to be taken into account. And so when it comes to looking at, for example, the resources available to the applicant, it's important to bear in mind not just what they've got coming in from salary and benefits, but also whether they've got any savings and other capital that might be relevant to whether they can actually afford their property, or whether that has a bearing on reasonable steps that may need to be taken. Importantly, Article 2 also mentions the different kinds of costs of accommodation that may be relevant. So not just rent or mortgage, but also things like service charge, council tax, mooring charges and fees, and also deposit that may also be needed. And again, I think that's likely to be particularly important for considering relevant steps, reasonable steps for prevention or relief duties. So, for example, if a homeless applicant is unlikely to be able to afford a deposit, then that's likely to have a bearing on what steps the local authority might need to take to prevent or relieve homelessness. Article 2 also mentions payments in relation to child support, maintenance payments, and also other reasonable living expenses need to be taken into account. So expenses relevant to the applicant beyond the costs of accommodation. And this issue of reasonable living expenses was one of the live issues in Patel and Hackney. There's a number of references in the Code of Guidance to affordability and how issues around affordability should be considered by local authorities. And they appear in various sections of the code, obviously depending on the context and what sort of stage a homelessness application may have got to. The section on homelessness in Chapter 6 basically just repeats what Article 2 of the order says that we just saw on the last slide. On intentional homelessness, local authorities are reminded that if an applicant is genuinely unable to keep up the rent or mortgage payments, then that's unlikely to amount to intentional homelessness, particularly where there's no further financial help available. There's also a relatively recent line on authorities being alert to the impact of economic abuse and control. So that's something additional that may need to be taken into account if you've got a client who's a potential victim of domestic violence or maybe a victim of trafficking. As I mentioned, assessments and PHBs also covers affordability. For example, the extent to which a plan for searching for accommodation needs to consider whether the applicant is likely to be able to afford a property within a certain geographical area. It may be that, if affordability is an issue, local authorities will need to expand the search a bit wider, taking into account the applicant's needs. And of course, suitability. So whether an applicant can actually afford housing costs without being deprived of those basic essentials. That's paragraph 17.46, which again was an issue in particular in Patel and Hackney. So lots of references, lots of help to local authorities and to applicants in the Code of Guidance as to how affordability ought to be considered. Just a sort of quick reminder of some of the cases pre-Samuels that were looking at affordability and looking at how local authorities were approaching those various considerations and how they were approaching that guidance in the code. Some of you might remember Birmingham and Balog, which was essentially a case where the Court of Appeal allowed the local authorities appeal in that case by finding that an assessment by the reviewing officer that the applicant could have reduced living expenses without having to sacrifice basic essentials would have made his accommodation affordable. So that sort of assessment of what actually is an essential living expense, what is reasonable, and are your sort of outgoings in excess of that? Is there anything that you could reduce? And the Court of Appeal said that was the kind of approach that the Code of Guidance was getting at. That's what local authorities should be doing, or reviewing officers should be doing. So said the Court of Appeal. There was a similar issue in Huzrat and Hounslow. This was a case where the reviewing officer found that, in particular, the applicant should have reduced the amount of pocket money she was giving to her children, and also should have avoided paying a debt to a friend if she was in a situation where she was in rent arrears. So in other words, those were examples of the type of living expense that the Court of Appeal said was open to a reviewing officer to find could have been reduced without sacrificing basic living expenses, without sort of going below those basic reasonable living standards. And so essentially she could have, it was found, reduce her spending to cover the rent so that it would have been reasonable for her to continue to occupy the property. And therefore the finding that she was intentionally homeless was upheld. But then a slightly different take in Farrer and Hillingdon. Similar similar circumstances to Husband and Hounslow, in the sense that single parent who had also had a shortfall between what her rent was and what housing benefit was actually paying. But in that case, the Court of Appeal found that the reviewing officer had failed to explain which items of expenditure were considered to be excessive or exaggerated. So what happened there was the reviewing officer said, I think your outgoings are too much, but hadn't actually said what should have been reduced, what was actually excessive. And the Court of Appeal found that meant the decision was flawed, it was unlawful, because essentially the applicant wasn't able to know the reasons for the finding. So it wasn't enough just to say, well, I think you're spending too much. You need to actually explain what it is that's meant to be excessive and how you're meant to reduce those expenses. So that's sort of where we were prior to Samuels. And I'm sure this is a case that's familiar to lots of people attending, but I'm just going to give a very quick run through of the background to Samuels. So Miss Samuels is a single parent with 4 children, and her income was solely comprised of welfare benefits. She had an assured short-hold tenancy of a property in Birmingham, and she fell into rent arrears and was given notice to leave. And Birmingham decided that she was intentionally homeless when she made her application, on the basis that the loss of her accommodation was caused by her having deliberately failing to pay the rent. So at the time she left the property, there was a shortfall not only in what housing benefit was paying, but also the totality of her income versus the totality of her expenses. She was left with a shortfall of £37 a month. In the 202 review, Birmingham's review officer said that I consider that it's a matter of normal householding budgeting, that you would manage your finances in such a way to ensure that you were able to meet your rental obligation, and therefore concluded that the accommodation had been affordable for Miss Samuels, and therefore that in turn she was intentionally homeless. Her appeal was dismissed at both county court level and in the Court of Appeal, and so she sought to appeal to the Supreme Court, which allowed her appeal. She argued that the reviewing officer was wrong to treat her non-housing benefit as containing a surplus, which could be treated as available to make up shortfalls between housing benefit and rent. And the Supreme Court agreed with her on that and made a number of very important findings in relation to the sort of resources and support that is available from welfare benefits, and how those are meant to be treated when it comes to assessing somebody's income and expenditure as required by the suitability order. The Supreme Court found that an assessment of what's reasonable needs to be objective. So it can't just depend on a subjective view of the reviewing officer. So there needs to be some level of sort of objective, neutral assessment of what is the reasonable living standard that's required for that applicant, for her family, or for the people that she would be reasonably expected to be living with. Affordability also has to be judged on the basis that the accommodation is to be available indefinitely. So said the Supreme Court anyway, a bit more on that later. So in other words, it's not just a snapshot of how things are on the day, but also going forward, is this a sustainable situation for the applicant? Benefit levels are not generally designed to provide a surplus above subsistence needs for the family, which again is quite an important finding in terms of whether there is anything sort of spare going over if there is a shortfall between, say, housing benefit or the housing cost element of universal credit versus what your accommodation costs actually are. So in other words, if a certain benefit is meant to be for a certain purpose, for example, the childcare element of universal credit or the standard allowance of universal credit, you shouldn't be expected to treat that as a surplus to make up for a shortfall if there is a difference between what housing benefit covers and what the rent covers. So that was also a very important finding. The reviewing officer therefore approached the case wrongly. The question isn't whether, when faced with a shortfall, Ms. Samuels could somehow manage her finances to bridge the gap, but rather what were her reasonable living expenses besides the rent, determined having regard to both her needs and those of the children, including the promotion of the children's welfare. So in other words, she succeeded because on the information available to Birmingham, the shortfall in her rent could only be met by a reduction in the standard of living set by the level of benefits received. And the Supreme Court said that was the wrong approach, and therefore she was successful. So a number of quite important findings there in Samuels. I'll just quickly go through Patel and Hackney before just having a bit of a chat about how that might apply a bit more broadly and some issues to think about going forward. Patel and Hackney is a slightly more, I suppose, slightly narrower issue than was addressed in Samuels, but quite an important one in terms of this issue of reasonable living expenses and how applicants should sort of try and approach that when it comes to presenting their finances on an issue to do with affordability. So a similar situation here in terms of the starting point, private rented accommodation for a family. In this case, Mr. Patel was actually evicted, as opposed to Ms. Samuels, who I think was just given notice to leave. Mr. Patel was actually evicted. At the time of his eviction, he had rent arrears of about £11,000. But just before the eviction was actually carried out, he made a homeless application where it was decided that he was intentionally homeless on the basis of deliberately not paying rent and that the property was affordable. Slightly unusually in this case, the decision maker at first instance, so at section 184 stage, the decision maker said that he'd underestimated the level of his family's expenditure. And so the decision maker inserted an additional figure of £32 a week to reflect payments for white goods. Essentially, they had to replace, I think it was the fridge and the washing machine, and had done that at their own expense. They'd purchased second-hand units at their own expense. At first instance, the decision maker said that should have been included in the assessment of the family's expenditure and came up with a figure of £32 a week. And so even though that was the figure that the decision maker had inserted, Mr. Patel adopted that figure. He submitted that the white goods were an essential expense, as the family had to replace those items. He was unrepresented at this point, and he was then taken on, I believe, at the 204 stage. At the review stage, the section 184 decision was upheld. The review officer disregarded the expenditure submitted for white goods, saying that he didn't think that these were an essential expense and that there was a sufficient flexibility in the weekly expenditure to cater for such eventualities. So in other words, even if you did have to replace those items, A, I don't think they're essential, and B, I think you had enough money anyway, and you still should have been able to pay your rent. And so upheld the decision that the accommodation was affordable and upheld the finding that Mr. Patel had made himself intentionally homeless. You might notice that on the reviewing officer's calculations, it was very close. The income was found to only exceed expenditure by just over £3. His appeal was dismissed in the county court and in the Court of Appeal. In his appeal, he placed particular reliance on the finding of Lord Carnworth in Samuels that an assessment of what living expenses were reasonable needs to be carried out objectively. And so it was argued unsuccessfully, partially unsuccessfully, I'd say, that summarily dismissing white goods as non-essential was contrary to that guidance. The reviewing officer should have done more to explain why white goods were considered not to be essential or a reasonable living expense. But it was held essentially on these particular facts that a finding that there was sufficient flexibility in the family's budget was one that was open to the reviewing officer. I think a particularly important passage is at paragraph 13, which I've put quite a big extract for you there on the slide. What's required is an inquiry into the needs of the particular applicant and his family, and imposes, again, repeating what the Supreme Court says, an objective standard for determining whether any expenditure relied on to prove that the accommodation was unaffordable should be taken into account. There must be an explanation that satisfies the test of reasonableness, And that can't be satisfied simply by reference to how the applicant has chosen to spend the money available to him. What's required is for a local authority to determine what in this particular case was a reasonable level of expenditure. What the Homelessness Code of Guidance says is that should be measured by what the applicant requires in order to provide as a minimum standard the basic essentials of life. So on the one hand, you might think, well, it seems a bit unfair to then say that white goods are not part of those minimum standards of basic essentials of life. I think in this case, it's really one that depends on the facts. I think if maybe the renter had been lower, that might have affected the court's approach. One of the issues that came up was the local authority's reliance on guidance from the Association of Housing Advice Services, or the AHAS guidance, which provided a much lower weekly figure for what they thought was reasonable to spend on replacing certain items in the home, such as white goods. And I think what's important to note as well is that, and as well as this passage, later in the judgment, it's a paragraph 33, the Court of Appeals sort of starts to suggest that expenditure for white goods could be considered a necessary and reasonable living expense, but more likely to be one that's an occasional outgoing rather than something regular. So white goods aren't necessarily out of the question. It's just that you might have to explain, if you're representing someone in a similar situation, how it comes about as a regular expense, or the particular timings for that particular what might be quite a large outgoing. And so having think about these cases going forward, and what this might mean in terms of good practice and trying to represent homeless applicants facing a similar situation, worth bearing in mind that there may be some wider application of some of those key findings in Samuel's beyond the homelessness context. And just to give one example that I've come across in my own work, in the asylum support context, if you're dealing with destitution, and where you've got what's referred to as a mixed household, so where maybe one member of the family is eligible for mainstream benefits, but the applicant for asylum support is not. Important to bear in mind what the Supreme Court said in Samuel's about benefits not providing more than a subsistence level. And I know that there's at least one or two cases in the Asylum Support Tribunal where the tribunal has accepted that universal credit meant to be for one person is not going to be enough to support somebody else as well. There may be other contexts where financial circumstances or destitution is a consideration, and Samuel's may be of some help there. As I mentioned, that I think care needs to be taken in terms of reliance on things like AHAS guidance or anything similar. The Samuel's judgment is very clear that objective measures are important in terms of consistency of decision making, and so any suggestion that applicants need less to live on than what subsistence benefits provide needs to be countered, I think, strongly. In terms of case preparation, I'm sure lots of people attending already do this very diligently, but the importance of mean statements in making representations in affordability cases is difficult to sort of to overstate. It's really, really critical that as much detail is provided, and if that's possible to be corroborated, even better. But basically, as much information that you can get on paper, presented nice and clearly for a decision maker or for a reviewing officer to really get a good picture of what actually is coming in, what's actually going out, and just sort of demonstrating that all those things are reasonable. Also important to have an understanding, I think, of the various deductions that might be coming out from people's benefits. Universal credit in particular, claimants are often subjected to a number of different deductions going on at once. You might be having deductions for a sanction, for example, that will take away 100% of your standard allowance. Depending on what the sanction was for, that could be for a couple of weeks, it could be for a much longer period of time. Things like court fines as well, or if your client is repaying advance payments from universal credit, or if they're repaying hardship payments that they've got, or if some other third-party deduction has been taken. It's important to bear in mind that what on paper they might be getting from universal credit isn't necessarily what they're actually receiving. And so I think it's important. It's really important to sort of demonstrate what is actually coming in, what's actually going out. That also, I think, has a bearing on how long a property can be unaffordable for. So obviously one of the questions is in terms of who's actually, if somebody is actually homeless, whether it's reasonable for them to continue to occupy a property. Well, how long are you looking at the picture for? Is it a sort of snapshot? Is it indefinitely, like what Samuel said? Or is it more like a situation in Safi and Samwell where you're looking at what's reasonable for the foreseeable future? You might remember Safi and Samwell was the case about suitability of accommodation that was overcrowded, where the applicant was pregnant. And so there was a property that was already overcrowded that was about to become even more so. And the reviewing officer in that case was criticised for not looking to the foreseeable future in that case, where there was an imminent change that was anticipated, that was foreseeable. If you've got a situation where somebody maybe is in a more precarious housing situation, then maybe how far you look forward depends on whether it's expected that somebody is going to be able to stay in that property for medium term or longer term. Equally, if there are issues with benefits, if there are deductions being taken out, how long do you anticipate those deductions going on for? That may also have an impact on your assessment of reasonableness to occupy a property that's unaffordable. So yeah, I think there's lots of things to sort of think about, especially following Samuel's, but also some of the guidance from Patel endorses a lot of what the Supreme Court says, and in particular the approach to things like essential living expenses and reasonable outgoings. But yeah, I think the main message is still going to be trying to get as much detail as possible in the needs statement, and really trying to explore the situation in terms of resources and outgoings, and make sure that's presented as clearly as possible, and that presents a realistic picture of what your client's situation is like. I think that is about it in terms of what I wanted to say. So thank you very much for your attention. I'm going to stop the share now and put myself on mute and hand over to Connor.
Great, thank you so much, Matt. That was really interesting. Connor, I think you're going to share your slides, is that right? And we'll hand over.
Yes, that's right.
Thank you.
So I'd like to pick up where Matt left off and imagine the situation where you've taken the sort of legal points that Matt has raised and you've succeeded in persuading the local housing authority that your client is in unsuitable accommodation. And the question then arises, what are you going to do about it? If that accommodation is not provided, how do you enforce the duty to provide suitable accommodation under Section 206? So I'm going to be looking at a few of the recent High Court challenges that we've had over the last 18 months or so in this area, and looking at the legal principles that have emerged from those cases, as well as the evidential principles that we can take from them. What evidence do you actually need to be gathering in order to give yourself the best chance of succeeding on a suitability challenge, as well as some procedural points that I think are worth considering in light of recent case law, recent changes to the admin court guide, and the recent practice direction 54B. So those are the three things I'm going to be looking at: law, evidence, procedure. And what I'm keen to do today is to try and give a few practical tips to navigate rather than resolve the legal issues that arise in these cases, and to deal with what I think is a rather different approach that we're now seeing from local housing authorities in the court. So what I mean by that specifically, when I talk about navigating rather than resolving the legal issues, you'll see as I go through, I think there are at least some inconsistencies, some difficulties that are quite hard to resolve between the recent High Court authorities. And there's also, as we'll see, points that are under appeal. So I'm not going to necessarily say what I think is the ultimate solution to all these difficulties. What I'm more interested in doing is acknowledging that these difficulties exist. How are we going to best prepare our cases to cater for these difficulties, really take into account the worst case scenario that if these cases do get to the High Court, then the High Court might not agree about how we represent the law. As to the change in approach by local housing authorities in the court, well, I think the change in approach by local housing authorities is illustrated by the fact we have seen 3 High Court challenges, which I will be discussing in due course, where local authorities have resisted attempts to provide suitable accommodation, even though they are in breach of duty. The fact that we've had this flurry of cases recently after a quiet period of several years is, I think, quite significant. In the time that I've been doing these cases, prior to the last year, I'd never come across a case where I've never had a case personally where we'd issued a suitability judicial review and the local authority had actively fought back, saying we're not, we can't, or we're not going to capitulate, we're not going to provide the accommodation. Generally, my experience is that you issue these cases, local authorities accept they're in fault and they do what they're required to reasonably quickly. I think that is changing, and that's the reason for that we can see from the Croydon case that I'm going to be discussing. So in that case, the contextual backdrop to that was Croydon was in a budget deficit of £66 million. They'd issued a Section 114 Local Government and Finance Act notice saying that their expenditure was outstripping their income. And the consequence of that notice in local government terms is that they are allowed to pare back their spending to bare essentials. Now, Croydon's not the only authority which has been in that sort of very difficult financial situation. So you can understand in that sort of climate why there is going to be resistance to complying with legal duties if they can possibly be avoided. As to the change in approach by the High Court, that's what I'll be coming to in the context of the procedural issues. But really, what I think you'll see when I come to that is we are dealing with a much more hostile climate in the administrative court to the bringing of urgent applications in particular. And it's really on us to make sure our cases are in order before going to court, because as you'll see, the consequences for us, specifically for barristers, for solicitors, if things aren't done properly, are very significant. It's not just that our client may not succeed in the case, there may be professional conduct implications for us. So that's the sort of context in which I'll be talking. So let's turn to the first of the points then, which is legal principles. I wanted to start off with the basic point, which I think everybody here will know, which is that there is a duty under Section 206 to provide suitable accommodation. And of course, where we see that duty being breached tends to be in instances of where the main housing duty is owed. Of course, there is duty to provide suitable accommodation in respect of other duties like the interim duty, but really where we tend to get involved, it's where the client is looking at being in unsuitable accommodation for a prolonged period of time. It tends to be main housing duties cases. And the challenges that I'm considering tend to arise in those instances where you've either persuaded the local authority on review or on appeal that the accommodation is unsuitable. So at that point, there is a breach of duty. There is a breach of duty. We know that from not only the older cases, but the recent High Court cases, 2 of them, Elkundi in Birmingham and M and Newham. Both of those cases have emphasised that the duty under Section 1932 is immediately unqualified and non-deferrable. So what that means in practical terms is as soon as the local authority fails to provide suitable accommodation, it is in breach. There is no reasonable time limit allowed under the legislation to provide the accommodation. It has to be provided forthwith, and if it's not, there's a breach. So I'll flag now that point is under appeal. So the Elkundi case, Birmingham have got permission to appeal on that point, on this big question of what is the nature of the main housing duty. And that, I think, illustrates the contextual issue that I've already flagged, that we're operating in a different climate where local authorities are doing what they can to pare back the duties that they owe. So watch this space. Everything I say from here on is based on the law as it currently stands, but Birmingham are seeking to appeal on that particular point. One of the reasons I start with this is not just to flag that Elkundi is under appeal, but also just to make the practical point that the fact that the duty is an immediate duty means there is scope for you to be getting your legal help file open at an early stage. Everything that I recommend from here on in are things, practical steps that are going to require funding. And I think you can justify getting the funding in place at a very early stage. As soon as you've won your review, as soon as you've won your appeal, you might want to give a couple of weeks to try and get the local housing authority to get its house in order. But as soon as you've done that, you have a legal issue there, which is legal aidable. And I think it's worth, for example, if you win an appeal, trying to get your client to keep in touch with you in those immediate weeks after the appeal, so they can tell you what is actually happening, if anything, with their case, and you can decide whether you need to open that new file to take these practical steps that I'm going to be advocating. So that's the nature of the main housing duty. The other important legal point is, in a suitability case, is what test is the High Court going to apply in deciding whether to grant a mandatory order? Because that's what you want. If you're going to court, you want a mandatory injunction from the court saying this client, this person must be accommodated within a set period of time, a few weeks, a few months, perhaps at the most. And this is one of the contentious areas. So we've got older cases like Cadona, where it was acknowledged that the court's not going to demand the impossible of local authorities, so mandatory relief is going to be refused in that case. Then of our more recent cases, we've got Mr. Justice Linden in M granting mandatory relief, saying he's not satisfied on the evidence, it's unreasonable to expect greater efforts, or impossible or unreasonably difficult to find alternative accommodation. And then you've got Mrs. Justice Stein in the Elkundi case saying something similar, granting mandatory relief to the lead claimant in that case on the basis that the council does not contend that it would be impossible to comply. Albeit she caveated that, she subjected that to caveat that the fact it doesn't necessarily follow that from that nothing less than impossibility would do. So we've got those three cases which are really focused on the steps that the local authority needs to take in deciding whether or not an order should be granted, and they're suggesting that the threshold is something like impossibility of compliance. But then you've got a very different approach in our other case from this year, which is Imam and Croydon. This was the case mentioned at the beginning, where Croydon was suffering from severe budget shortages. And in that case, mandatory relief was refused, notwithstanding the fact that the claimant in this case had been in the property for 5 years, during which time it had been unsuitable. And what the Deputy High Court judge said in that case was the claimant hasn't established that the conditions which she is presently living in are having an extremely serious effect on her, or that the situation is intolerable. And he reached that conclusion by cutting and pasting a few dicta from the Supreme Court decision in Ali and Birmingham. So Ali and Birmingham was about reasonableness of continued occupation of refuges, among other cases. It was the case that establishes that what's reasonable in the short term might not be reasonable in the long term. So it wasn't a case about the test for mandatory relief. It was a case about how long you can be reasonably expected to continue to occupy. So a very different context, but dicta from that case spliced into the suitability context, and with the result that this very different threshold is applied. And it is, I think, a divergent approach, because the former approach, asking whether it's impossible for the local authority to comply, is focusing on what the local authority has done, what they can do, and it's placing the burden of proof on the local authority to show that they could not comply with an order. But the approach in Imam is fundamentally different. It's flipping the burden of proof. It's asking the claimant to prove their case, and it's changing the standard of proof. It's asking the claimant to show that things have got to an intolerable level. Now, for what it's worth, I think the decision in Imam must be wrong. Like, without getting bogged down in the niceties of housing law and whether or not the Deputy High Court judge in Imam was correct to borrow from the Supreme Court decision in Ali, it's a cardinal principle of public law. The public law exists to ensure that local authorities do not act unlawfully. If a local authority is acting unlawfully and is doing so on an ongoing basis and is refusing to stop, claimants shouldn't have to demonstrate that they meet some super high threshold in order to justify the intervention of the court. I think personal circumstances of claimants can be relevant, are relevant, but they shouldn't be decisive in that way. It shouldn't be up to a claimant to say, this isn't just an illegality, it's a really, really bad one, and that's why the court should intervene. That just seems to be antithetical to basic principles of administrative law. But coming back to where I came in, I want to focus on practical points. We have these divergent cases. In preparing your case, in preparing your client's case, how are you going to deal with them? Well, I think probably the answer is not to get het up on the legal test, because that's something that's going to be argued about in court, but really look at the factors that underpin the legal tests in all the cases and take those factors and try and get evidence to show that they exist in your case. So you essentially cater for the worst case scenario, cater that the High Court is going to say, well, I think I'm going to follow Imam, and make sure that your evidence is good enough to show that even if that happens, you should still get a mandatory order, show that your client's living conditions are intolerable. So breaking that down in a little more detail, if we look at the factors which have actually been taken into account in all those three cases, Elkundi, Imam, what we have is the list I have at the bottom of this slide. So first of all, we're looking at the reasonableness of the local housing authority's position by reference to the steps that they're taking, bearing in mind that the context is they are in breach of a mandatory duty. So that's the kind of thing that you want to feature in your evidence. You want to, although you're not personally going to know what steps are going on behind the scenes, if you have been writing to the local authority constantly over a period of months and they haven't responded, you can infer from that reasonably that they are not doing anything. That's going to go in your evidence. You want to be evidencing the nature of the accommodation being occupied. That's another factor that featured in all of the cases. The length of time local authority been in breach, the efforts they've made, the likelihood of accommodation being made available in the near future. Okay, that's possibly not something your client can attest to, not something you can attest to, but the other points certainly. And then perhaps most fundamentally, particularly looking at the way it was approached in Imam, was the seriousness of the deficiencies of the property in terms of their nature and effect. So that is about impact. It's about impact on your client. You want evidence showing just how bad things are, and then any other particular factors in relation to the case. So it's a non-exhaustive list. So that list is really, I've cobbled that together from these three cases. And although the test applied by the High Court in those three cases is slightly different, the underlying factors are pretty similar. And so I think it's fairly safe when you're preparing your case to focus on those factors in deciding what evidence you gather. So that really, I think, provides much of the answer to the next of the points I wanted to take you through, which was about evidence gathering. So those relevant factors dictate the evidence which you are going to be gathering to maximize your chances of getting a mandatory order if the local authority does fight this case. And evidence of impact on your client is likely to be significant, if not critical. So in Imam, interim relief was refused with mandatory relief was refused with the judge saying there was no evidence about the effect on the claimant of the unsuitable conditions in which he was living beyond the terms of the letter of the claimant's solicitors of 23 April 2015. So that was the initial letter to the local authority saying why this wasn't suitable, which prompted the local authority to accept that it wasn't suitable. And then 5 years later, they're still not moved. So that evidence is crucial. And it's worth highlighting that, because I don't think the claimant in Imam were being unreasonable or showing a lack of foresight in not having their evidence. They explained their position to the judge very clearly, which is essentially, why should we have to evidence this? The local authority is accepted it's breaking the law. Why should it be up to us to demonstrate what is wrong with that? There is no factual dispute here. The local authority accepts it's not suitable, and there's been a significant period of time when nothing has been done, so therefore we should get relief. So I have a certain amount of sympathy with that approach, but the judge didn't, and so we have to prepare our cases on the basis that our judge also might not, and we want that evidence of just how bad things are. That could be anything, really. It could, most obviously, it's going to be medical evidence. In particular, if you can get expert medical evidence of the impact on the client, that's going to be good. But don't overlook just your basic witness statement, which you're going to have to prepare for the JR anyway, setting out the day-to-day impact on your client of living in these conditions. And I know that's easier said than done, particularly where you have vulnerable clients who have mental health problems, physical health problems. The kind of person who's going to get in a suitability dispute may well be the kind of person who's going to struggle to give you the best account of just how bad things are for them day to day. But the time you spend with them putting that witness statement together is going to, I think, pay dividends if you do need to bring this judicial review. Social services evidence as well. If you've got families in unsuitable accommodation, social services will often express a view about overcrowded accommodation, for example. That's what you need to make good on your case. And it's worth thinking about this early on, because some of this is going to take a long time to get. You're not going to get social services evidence immediately. If you need an expert report, it's not going to happen within a few days. You want to be thinking about it really as soon as you think the local authority is in breach. You want to be thinking about a very early stage. And a lot of this evidence you may already have gathered in the course of your initial review representations where you persuaded the local authority that the accommodation wasn't suitable. But I find often in these cases, by the time you get to considering judicial review of the failure to comply with the Section 206 duty, often a lot of water has flowed under the bridge. You may have succeeded in your suitability challenge 6 months, 12 months previously. And so the evidence that you do have may not be up to date. It may be compelling, but it may not be up to date. And I think the first question a judge is going to ask when faced with compelling evidence that's a year old is, well, what's the position now? This person, it sounds like things were awful, but this person's managed to stay in the accommodation for a further year. Or I think it's really that bad. So that's what you need to be getting together. And you do need to be presenting that, I think, to the local authority to consider before you issue, because it may affect how they deal with the case. The court will want to show that you've given them the chance to respond. So again, all of that affects your timetabling. You don't want to be in a position, I think, where you're instructing counsel saying, look, we've got a clear breach of duty. Do you think we can issue this week? And then counsel is coming back and saying, well, actually, you need to gather all this evidence. We need to put it to the local authority, because that's going to put your timetable back considerably. So you want to be trying to get that early and factor all that in. And you also want to be managing your client's expectations that because all of this is likely to be needed, this is not really, except in rare cases, it's going to be something you can deal with immediately. It's going to take a bit of time. Point I've already alluded to in the context of the legal principles, having that paper trail of requests to the local housing authority, pressing them for action and updates, I think is really important. That is the way that you're going to flush out the reasonableness or unreasonableness of their response. If you just write once saying you're in breach of duty and then leave it for a few months, that may conceivably be enough to get you to court, but it's not going to be a compelling way of showing that this local authority is doing nothing. On the other hand, if you've been writing to them every week saying, what is going on? You're in breach of duty. Our client's suffering. What are you actually doing? If you've got that sort of paper trail, which has not been responded to, then really the only inference that a judge is going to take from that is that nothing has been going on and that the local authority's position is unreasonable. So that, I think, is important evidence to show that you have a case where mandatory relief is warranted. So those are the sort of things I think you should be looking for in terms of evidence to bolster your application for relief. But evidence is also relevant in another way. Evidence is also relevant not just to try and get your order, but it's also relevant when you're trying to get the court to consider this urgently. So the goal in suitability cases ultimately is to either get your is to get interim relief, an interim injunction getting required the local authority to move a client, or at the very least expedition, a recognition from the court that although an interim order is not warranted, that your case is sufficiently dire that the case needs dealt with quickly. So that is your end goal, and you're going to need evidence to underpin that. So I'll come back to the evidential points, but just to pick up before I do on a point I raised at the beginning, what we have now in the administrative court is a much more stringent approach to urgent applications. The recent practice direction 54B puts a lot more emphasis on the involving the defendant in urgent decision-making process. So what I mean by that is it has been known, particularly in immigration cases, for the judges of the administrative court dealing with urgent cases to actively invite the defendant to respond. So people have put in requests for orders asking for them to be considered with 2 or 3 days, and the court has come back saying to the defendant, this is what the claimant is seeking. What is your position? You have 7 days to respond. So the judges are really entering the arena, taking things into their own hands, and as a result, lengthening the timetable. So that's one of the changes in the admin court, but there's also a much more robust approach to non-compliance. So I'll come back to this, but essentially, if we don't get these procedural points right, there are conduct issues that arise for us. So the two things I'd urge you to look at in relation to procedure are the new admin court JR guide. So in the last few weeks, last month, we've got 2021 judicial review guide available online, which reflects a lot of what I'm saying now. It reflects the very recent case law. We've also got our new practice direction 54B. Those really are the essential reading for the urgent applications. And it's not just things you want to read the day you're making an urgent application. They're things you want to look at now because they affect 6 weeks before how you prepare these cases, in my view. So second bullet point on the slide, just to really hammer home what I consider to be this different climate. In the admin court guide, for the first time, we've got an observation that the appellate courts have identified an increasing need for appropriate procedural rigour in judicial review. If legal representatives fail to comply with procedural requirements, there are a range of sanctions at the court's disposal. So that's really just illustrating the point I'm making. And these aren't just points which are relevant to whoever you would counsel, who you instruct to do the case. Like the new approach affects how you go about evidence gathering. It affects how you interact with the defendant. It affects whether further pre-action steps are required and how you manage the client's expectations about timetabling. And then obviously professional conduct sanctions. If you're called into court to justify why you've done something wrong, that affects everybody. It affects solicitors, it affects counsel. So that's why we need to get this right, all of us. First, in that climate, then first procedural issue dealing with an urgent case, firstly work out how urgent your case really is. How urgent is urgent? So the N463 urgent consideration form is for cases that need judicial input within 7 days. What the admin court says about that, or what it observes, is it will very often be possible to point to a reason why the claim would be better served if an application were determined quickly. But that's not enough to justify using the court's procedures for urgent consideration. Those procedures are made available only for urgent cases where there is a genuine need for the application to be considered urgently. So really, you need to assess whether or not your case is actually so urgent that there is this genuine need. Because as I say, with suitability cases, although we're often dealing with vulnerable clients in difficult circumstances, we're also often dealing with people who've managed to get by just for a reasonable length of time. So do you really need the judge to look at it within 7 days, or could it be a bit longer? So that means deciding, have you got evidence, or can you get evidence of genuine need? What does that mean? Well, based on the subsequent paragraphs in the admin court guide, I think what genuine need means is whether the client's going to suffer irreparable consequences. So there's a high threshold there. So you're going to need evidence to show that that threshold is met. Otherwise, you may well be met by a high court judge saying, I'm not dealing with this urgently, and I want to call you into court to justify why you've asked me to do so. So the kind of evidence you need is exactly the kind of evidence which you're going to be getting to show why you should get a mandatory order. There's overlap here. You're going to be looking at client or medical evidence of the impact of the property conditions on their lives. But also evidence that's realistic in taking into account the fact they might have been there for a prolonged period of time. So really, in gathering that sort of evidence, the things you need to think about are in the list on the first bullet point of the slide. So firstly, the court's going to want you to evidence why the claim hasn't been issued earlier. A lot of the time, you won't have issued previously because you were doing the reasonable thing and giving the local authority a chance to reply, a chance to get the house in order. That's fine if that is the answer, but you'll need to put that in your evidence. And you need to reference that with reference to your correspondence with the local authority. So again, this is a facet of your case where if you've got a paper trail over many months of you haranguing the local authority, encouraging them to act, that's going to be relevant evidence. Also, crucially, in terms of client circumstances, has something changed? Have their conditions got worse? Has there been a loss of mobility, for example? It means they can't use the stairs any longer, or a mental impairment that's got lost, which means that there's been some kind of tipping point reached. That might justify urgent intervention, notwithstanding the fact they've been there for a while already. So kind of example I was thinking of is maybe you have a client who's surviving with a carer, but the carer is looking after them 24 hours a day. Is it breaking point? Maybe you've got a client where things have become urgent simply because it's a process of attrition. It's not that circumstances have changed. It's just that every day that goes by, it gets harder and harder for them to survive in the property. Their mental health is deteriorating day by day because they don't have, for example, the support network they need, because maybe they're housed out of borough. That's the kind of thing. Or is it that you've got an ever-present risk that hasn't materialized yet? So maybe you've got a client who has a suicide risk or a risk of self-harm. And yes, they have been in the property for a year already, but that risk is present. It's with them every day. That could justify, I think, urgent intervention within 7 days. As I said, all of this overlaps with the kind of evidence you want to get your mandatory order. So you will have been thinking about it anyway. if you can't get that sort of evidence, if realistically your case is not that serious, if there's no sufficient evidence of genuine need, you might still be able to ask the court to expedite, to ask it to deal with it more quickly than the norm. But that shouldn't be done in the N463. It should be done by means of a normal application, an N244 application. So one of the recent cases I was talking about the changing climate in the admin court, is this application for judicial review. That was a Hamid referral. That was a case where the advocate in the case was hauled in front of the administrative court to justify why he'd asked the court to consider a case within 48 hours, which involved a challenge to some regulations. It was relatively urgent, but not super urgent. And the point that the claimants made in that case was, well, we needed it dealt with more quickly than normal. And the court took a very, very hard line on that, saying that's not what this urgent process is for. And I think that really illustrates the sort of harshness of the climate in the admin court at the moment, because I personally look at that and think, well, that might be a reason to refuse relief. That's not necessarily a reason to haul the legal team in front of the High Court and assert that they've misconducted themselves. But that was the approach taken, and that's why we need to be worrying about these things and getting them right. Finally, to finish up in the last few minutes, other procedural developments in this recent changed climate in the admin court involves much more emphasis on involvement of the defendant. And you can see that both from Practice Direction 54B and the other Hamid referral we've had this year, which is DVP and Secretary of State for the Home Department. So in broad terms, what the court will expect you to have done is to investigate the defendant's position, try to find out the reasons why they're not complying with their duty, ascertain whether there are good reasons for them not complying, and then you will need in candor to put that information to the court. It would need to go in your N463. It affects your timetable because the court will, in a lot of cases, want to hear from the defendant before making an order. So I think really the days of getting ex parte orders on the papers in this sort of case are over. Much more likely is you're going to have an inter partes hearing sometime after you've lodged, maybe a week after you've lodged, where the defendant has the chance to make their case. So in terms of your case preparation, the more you can do earlier on to try and find out why the defendant is not doing what it should, the more likely you are to be able to persuade a judge that actually this case should be dealt with very urgently, and perhaps in an extreme case even without a hearing, because you can then show that the defendant has been given fair opportunity to respond and hasn't responded. So if you've done that in advance, then by the time you actually get to court, it's going to smooth the way for you to get the sort of order that you are looking for. So to finish up then, getting mandatory relief in suitability cases, I think, raises some difficult issues. We've got the issue which is under appeal in Elkundi about what actually is the nature of the main housing duty, but we've also got a conflict, I think, in approach between the recent High Court cases on when the court should grant a mandatory order. So the law's in a bit of a state of flux and certainly in a state of complexity, but in practical terms, if you want to get an order, what you need, I think, is evidence of ongoing impact on your client being in the unsuitable accommodation, coupled with this paper trail to establish the attempts that you've made, that your clients made, to encourage the local housing authority to act. And that will serve to highlight any intransigence on the part of the local authority to flush out the unreasonableness of their position. All of that's going to bolster your chances of success. That's the evidence you need to try and get a mandatory order. But in gathering this evidence and putting it together and communicating, writing to the local housing authority, I think you also need to be thinking ahead to the possibility that you might at some point have to make an urgent application to the court. And that informs your process, because you're going to need to explain the delay. Any delay, you're going to need to justify to the court why the matter needs dealt with urgently. And you're going to be able to need to show that you've investigated the reasons for local housing authorities' failure to act and given a fair opportunity for the authority to present its case. But if you've done all that, then I think you are putting your client in the best possible place to try and get an order requiring them to be moved to suitable accommodation. So I'll stop there. I think we're just about on time, and we should now have a little bit of time for some discussion.
Great. Thanks very much, Connor, and thanks again, Matt. Two really helpful and interesting, in places slightly chilling presentations, but really, really useful for our practice. So we've got a couple of questions, but please do, if you have questions that you haven't yet put in the Q&A box, please do pop them there, or just indicate that you have a question, and we'll try our best to answer it. So I can see that Mark Richard asked whether Imam is being appealed, and Matt, you've said that well, it is essentially that we're waiting, or not, the claimant's waiting for a decision on permission to appeal. Is that right?
What the case tracker says, that decision is awaiting on the papers. So yeah, quite early stages.
Connor, I don't know if you have any sort of more on that. I mean, I don't.
No, I don't. I mean, I'd just add that it's clearly an important legal point there, and it's eminently open to debate. So I hope they get permission, but I don't know, I'm afraid.
Right, thank you. So we think so is the answer, but yeah, doesn't know that there's a decision on that yet. So there was also a question from, I think actually we've got a contribution to that from Becky, who says that she looked on the file and doesn't seem to be anything from the court since it was issued in May. Can we maybe, Amy, unmute Becky? Becky, are you unmuted? Do we have Becky?
Can you hear me now?
Just about. If you could speak up a bit, that would be great. Thank you.
Sorry, it's not actually my case, it's Polly's. So I just had a quick look on the file, and there's nothing since it was issued, but it has been issued. That I don't know what the turnaround time between issuing an appeal and actually getting any kind of hearing date is. That was actually something I was going to ask.
Okay, great, thanks. That's really helpful. So an application for permission to appeal has been lodged, but you've not had it, but no response yet. In terms of the time, I mean, it really seems to vary hugely in my experience. Certainly, I don't think a wait of months is unusual, unfortunately. I don't know, Connor or Matt, if you have any kind of particular thoughts on that, but it's hard to say. But yeah, certainly months wouldn't be surprising.
Yeah, I think that's right. I guess the only point I'd add is that I suppose it's possible that some of the issues which will be under appeal in Imam could be dealt with in Elkundi, although that's not the central point. There's such an overlap between these issues. I think the Court of Appeal will have to deal with them in whichever case gets to it first. So if Elkundi gets there first, then maybe that's the one to watch out for.
Great, thanks, Connor, and thanks very much, Becky, for that input. Really helpful. So we've also had a question from Sandra Francis. So I wonder, Amy, if we could unmute Sandra for her to ask that question. Great. So Sandra, I think you are allowed to talk, but I think you're currently on mute.
Can you hear me now?
We can, yes, thank you.
Yeah, thank you for that. I was recently going to refer a JR to Garden Court, but the local authority backed down in the end and has provided interim accommodation on application for a homelessness application. My client is very vulnerable. He's age 78 with 2 dependents, and he was having difficulty in providing all the evidence to me. So naturally, I asked for the housing file. And as Connor has said, we need to gather a lot of evidence and so forth. And to this day, they still haven't given me the housing file since August, although they've recently backed down last week, and my client has been provided with accommodation in a hotel this week, Tuesday. My thing is, I did quote the GDPR regulations for a subject access request, and I just wondered, in this evidence of gathering, and we've got vulnerable clients, we can't always ascertain all the facts and look behind the scenes with the local authorities. So I just wondered what the panel's view was on this about the housing file. I do believe there is case law where the housing file is not an integral part of putting forward evidence, that you can't hang around for the housing file. But in this instance, I really did need to gather more evidence on how the local authority had erred with my client over a 3-year period. So I just wondered what the panel felt about that in relation to evidence.
So is the issue there, Sandra? Obviously, I don't want to. I'm not asking about any kind of personal details of the case, but your client's being provided with Section 188 accommodation, and you need the housing file to put forward a case on
a judicial review. Yes, because we threatened the judicial review last week, and the local authority backed down. But I have been asking for the housing file for 3 or 4 months in order to find out, because during the pandemic, most of the housing officers were dealing with clients on the telephone without any written notifications or evidence that the client could provide to me that he had contact with the local authority. So I asked for the housing file so I could see what was going on behind the scenes, and they still haven't provided it since August.
So there isn't an ongoing, I mean, I'm sure there will be some down the track, but at the moment, accommodation is being provided and there isn't an outstanding dispute, is that right?
Yeah, not at this time. It's just happened on this Tuesday.
Right.
I was wondering about gathering the evidence very early. I often ask for the housing file very early, but this local authority has not provided it at all. So I just wondered what the panel felt on gathering the evidence very early, as we're discussing now, and how the housing file can help us to gather that evidence.
Yeah, Connor, do you want to come in on that?
Yeah, I mean, I think in the kind of cases I'm talking about, in suitability challenges, it's generally the case that you will have that information by that stage, because you're talking with a challenge that has arisen either after a review or after an appeal. So really, they should have given you the information by that stage. Even if you don't have it, it's probably not critical to the sort of evidence gathering I'm envisioning, because what I'm talking about primarily is evidence of the impact on your client, which if you've got a client who can't tell you that, you're going to get external medical evidence, something like that. And as the evidence of a local authority's intransigence is going to be demonstrated just by you writing to them and then failing to respond. So more generally, what can you do if you need a housing file and don't get it? I mean, I think I'm a bit wary of answering this without looking at what the remedies are within the GDPR, for example. But what I would suggest tentatively is, I mean, if it's not urgent, then obviously you can pursue internal complaints processes, and that is the way to do it. But if it is urgent, as your case sounded like it was becoming, then probably you're in a situation where you might have to just issue on the limited evidence you have. If you have a prima facie case of illegality on the basis of what your client has said, you've put that to the local authority in a letter before action. That is their opportunity to rebut it and say, your version of events is not accurate. That is not how things went. Here is the housing file to show that is the case. If they don't do that, I think you are reasonably well placed to issue your judicial review, at which point the duty of candor, which applies in public law proceedings, arises, and they will have to give you that material. And of course, if they give you that material and at that point you realize that your case is actually misconceived because there are a lot of things they should have told you but they didn't, then you're going to withdraw your JR, but you should get your costs.
Yes, thank you for that clarity. I
think the only thing I would add to that is that the Information Commissioner's Office recommends that you complain to the ICO if, for example, a subject access request is late and it's not been responded to. It may not be all that much help in an urgent case like the one you're describing, but it might be something to sort of throw at them as well if you're still waiting for a file, even if it's not urgent at the moment.
Yes, thank you. Thanks for that clarity.
Great, thanks. And I can see we've got a couple of comments in the Q&A from David Watkinson, a comment that when he was in practice, the remedy would be to apply for a JR for the failure to provide it. And Rachel Lovell saying that you could, if it's not urgent, then you can complain to the ICO. And I would have thought those were probably, certainly a complaint to the ICO, probably going through the in-house complaint procedure first. Obviously with our ongoing proceedings, and you can make an application for disclosure within them, or as Connor says, you know, you've done your best, if you've got the instructions to go ahead proceeding on that basis. Okay, thank you so much, Sandra, for that. If I could just ask Sandra and Becky to mute yourselves, or Amy perhaps to just adjust that, that's great, thanks very much. So do we have any other questions? Please do raise your hand or put them in the Q&A or in the chat if there's anything you wanted to ask. Connor, one thing I was wondering from your presentation is in relation to your suggestion that the evidence that you gather should be presented to the local housing authority before issuing. I was just sort of wondering about that, because obviously if you were to JR sort of a particular decision, then of course you need to provide the evidence before the decision. You can't sort of provide evidence after and try to kind of get it in that way. But when the evidence is going to remedy and the exercise of the court's discretion, is that more just a kind of a fairness point, do you think, or why do you think that's something important to do?
I think it's certainly relevant to fairness, and it's also, I think, relevant to the potential counter arguments that the defendant might make. So can I just caveat that before I develop that answer, which is, if you've got a super urgent case where somebody just cannot survive for a day longer in their accommodation, particularly suicide risk cases, then as long as you've written your letter before action, you're not going to go through quite the convoluted process I've suggested. I'm more thinking about cases where there is a little bit of time to play with. The reason I think you should, in those cases, present the evidence are, firstly, because I think that is the direction of travel in the admin court. Like that, they want to hear from the defendant. They want the defendant to have had an opportunity to have their say. And that is going to mean considering the most up-to-date evidence, because although that evidence goes to relief rather than the underlying error of law, it may affect the defendant's approach. The defendant might have a lot of other people in similar situations who should be provided with accommodation but haven't been, and it may be that they're not prioritizing your client because they don't think your client is the most urgent case. So actually, if you'd given them this evidence, maybe that would have changed their approach. So it is potentially relevant to relief. Really, again, I guess that, relief and fairness, it's both of those things. I just think that although it's not a hard and fast rule, if you have done that, if you have luxury of time to do that, you're going to have more chance of getting the relief you want, and not have a judge say, well, you should have shown this to the other side, and not having your opponent say, oh, well, we didn't know about this. If we'd known about this, we would have acted far quicker. You're just preempting the points that might be taken against you.
Great, thanks. Yeah, no, that one makes complete sense. So we've had a question from Jensen Lam. Amy, could we please unmute Jensen?
I think Jensen said he doesn't want to read that out.
Oh, okay. So shy, Jensen. Right, I'll read it out then. So they were having a chat. Jensen was having a chat with Derek from Camden Law Centre about out-of-borough placements, which is a very vexed issue, as we know. In Zola Macy, the court emphasised the need for local authorities to house within the borough, or failing that, as close to the borough as possible, which is obviously the statutory obligation. And then in Elkundi and Brent, the court said that local authorities don't need to, quote, scour every estate agent's window between Brent and Birmingham. So if the latter is the approach of the courts, then it becomes pretty tough to challenge out-of-borough placements. What approach would the panel take to showing that an out-of-borough placement is unlawful if the court takes the latter approach, outside of the usual Section 11 personal circumstances such as work points? Oh yes, I can see PS. I don't want to read this out. Sorry about that. So yeah, it's a good question. Out-of-borough placements are very difficult. Matt, do you have any kind of thoughts on that?
I think my instinct would be to not necessarily go to the approach of scouring every estate agents, but at least trying to demonstrate that if you're not in borough, have you at least looked in the next one, or maybe the one after that, the sort of concentric circles kind of approach that I think was even mentioned in Zola Mesa as part of the idea. So not sort of demanding a sort of really sort of root and branch search for every possible estate agent that might possibly be able to find somewhere, but at least taking a sort of methodical approach and starting locally, or starting within the area that your client says is suitable, and at least starting there and going in sort of concentric circles outwards. I think that seems to me a more sort of logical approach to do it. That doesn't require looking in the window of every possible office, but at least there's a sort of method to it and a reasonableness to it. And if they can't demonstrate that, then that might be something to go on in terms of whether they've approached the situation lawfully. But yeah, it is always going to be difficult, and I think local authorities will will always say, we did try, but there isn't anywhere in the time that was required. This was the best that we could do in the circumstances of this case, sort of thing. And it is difficult. As I say, I think if you can demonstrate some sort of reasonable approach that you think is proportionate, and they don't have an answer for why they haven't adopted that or why they've gone the way that they have gone, that might be something to work with.
Great, thank you. Connor, do you want to chip in on that at all?
Yeah, I think post and Zola Meso, and this was the case in LBC, most authorities have two policies on temporary accommodation. They have one policy on the procurement of the accommodation, which is how they go about getting the properties between Brent and Birmingham, what areas they have properties in. And then they have one policy on allocating those properties. So you want to get both of those policies at the earliest possible stage, i.e. during the review process. You want disclosure of those policies to assess whether there has been compliance with those policies, and to consider whether the policies themselves are lawful. Because, for example, if it's the case that local authority have procured accommodation that is only in Birmingham, then I don't think that procurement policy is necessarily compliant with Section 208. And so we know from Adesoto, if you want to raise that kind of big public law policy challenge, you need to have raised that during the review. So get those two policies and have a think about compliance and challenging the policy itself. But you also want to get the evidence of the local authorities' compliance with those policies. So what I mean by that specifically is the local authorities should have records of what properties they had available on the day in the areas in which they have accommodation. So if they've only got properties in Brent, Milton Keynes and Birmingham, they should be able to tell you that, and they should be able to tell you exactly what properties were available on the day. So having that information is integral to assessing whether there has been compliance with those policies. I mean, I'll just add as an aside, Jensen, I agree with you completely. It is really hard to bring these challenges, and notwithstanding the sort of advice I've just given, the thing that's really galling about the decision in Alad is actually there was a property which was available closer than Birmingham, which should really have been allocated in accordance with the policy. And the Court of Appeal just glossed over it and said that the sort of reasoning in the review decision was enough to justify why that hadn't been given. So it's a difficult climate, but I think if you take that sort of approach, you're setting yourself up as well as you can. But if you want to raise big public law arguments about the legality of policies, you've got to raise that earlier. You're not going to be able to raise that on appeal if you haven't raised it during the review.
Thanks very much. I can see that we've got an interesting point in the Q&A box from Aranta. Sorry, I'm really sorry if I'm mispronouncing that, but I wonder if we could unmute you, and also Amy. I think Kevin had his hand up, although it seems to have gone down again. But if we could perhaps unmute Kevin in case he wants to. Kevin Gannon. Great, thank you. Aranta, do you want to just kind of speak to that point that you made in the Q&A?
Hi. I was just, my question is whether the courts will take into account the fact that the reason that the local authority has to put people outside the borough is because there is no social housing. That's just going to keep happening in our borough. It's Kensington and Chelsea. And obviously we know what happened there. I'm on the Grenfell project, but basically they've said they're just going to start resettling people outside of the borough because they don't have it. But there's big developments being built, but they're not for social rent. There's small percentage of this and small percentage of that. So how do you challenge that when, the reason is that with the scarcity, but they keep with the policies, it's getting more and more scarce?
Yeah, it's a really good point. And it's just incredibly frustrating. I mean, I think it's a tricky one to bring in and to rely on, because I suppose if you could point to some, unless you're able to point to some kind of clear duty to build social housing, and then sort of rely on that failure to comply with duty as kind of vitiating the decision made, which comes as a consequence of that. The analogy that I'm thinking of is Gypsy and Traveller cases. They've been for decades a failure to comply with the duty now repealed, but the duty that used to exist to provide pitches for gypsies and travellers and it was brought repeatedly before the High Courts, but it didn't really ever kind of produce this result that the decisions that were made kind of in consequence of that failure to comply with the duty meant that they couldn't, for example, evict or accommodate in different areas. So certainly if that's relevant, then I think that does make it tricky. Matt or Connor, do either of you want to contribute to that?
I think that the courts would certainly take into account the fact that there isn't enough social housing. You know, the duty that's underpinning all of this is the Section 2.8 duty to accommodate in borough insofar as reasonably practicable. So if there's no accommodation built in borough, then the court's certainly going to accept that's a lawful basis for why people are being shunted outside of borough. But that can only be taken so far. I mean, you've said that 75% are going out of borough. I mean, that's getting very high. Conceptually, there must be a point where you house so many people out of borough that you are no longer performing the Section 208 duty. Like the most clear-cut case, if you accommodate everybody out of borough, then you can't also say that you're accommodating in borough as far as reasonably practicable. And you've mentioned that it's the lack of social housing that's the issue. That's one issue, but it's not the only issue, because that's not the only way local authorities can provide temporary accommodation. They could get private sector accommodation in borough. So if your borough's procurement policy is such that they are only considering social housing, and because they don't have it, they are predominantly allocating outside of borough, then maybe there's a challenge to the procurement policy there in that they're limiting themselves by only considering one type of housing. Now, I'm not saying that's necessarily the case here. I'm sure Kensington and Chelsea have got some quite sophisticated advice on their policies, but I think this is the kind of thing we need to be thinking about, because as Jensen has said, these challenges are getting so hard that this Section 208 duty is becoming something of a dead letter because there's so little housing. So I think we need to be thinking along the lines you suggest in thinking about whether we can challenge the underlying policies.
Great, thank you. Matt, did you want to come in on that? I know we've also now got Kevin unmuted. So Matt, do you want to go first and then Kevin?
I'm not sure I had much to add, really. I think, it's just where, as Connor said, it's not just about trying to find social housing for a homeless applicant or family. It's whether there's private accommodation that might be available in borough as well. So if they're saying there's neither, then that might point to some sort of systemic policy that may be challengeable. But in individual cases, it is difficult.
Yeah.
Thank you. It's too expensive.
Kevin.
Yes. Hello, everybody. Thanks very much, Tessa, and thanks, Matt and Connor. I just want to add just a couple of brief things to build on what Connor has said about out-of-borough policies. I had a case, a couple of cases actually, where in the first one I looked at some statistics to find that a local authority was a bit out of line with other local authorities in the proportion of out-of-borough properties that out-of-borough households. They seem to be higher than nearby authorities, but although we were allowed to challenge that in the 204 appeal, it was very easy for the local authority to say, well, there were all these other factors that mean that affected our proportion. We had another case where we found out that the local authority was using properties that it had procured under a joint venture with a private organisation, and the terms of the joint venture agreement limited the number of properties that would be found within that joint venture in borough. And so we said, well, you know, if they use this joint venture, that's got a built-in non-compliance with Section 208. But we were not successful in that argument either, because of course the 208 duty applies in relation to all of the property that's procured by the local authority, and the joint venture wasn't the whole picture for that particular local authority. What the conclusion from those cases is that when you look at some of these procurement policies, what you'll see is they're very aspirational in in the way that they express themselves. And they'll often say things like, the council aims to accommodate all its homeless applicants in borough. And with that in mind, we will do this and we will do that. And it's very hard to actually say on the face of the policy that is unlawful, because it aspires to comply with Section 208. But the proof of the pudding is in the practical outcome. And one of the things that it occurred to me after those cases that I was involved in is that we need to have some freedom of information requests made of local authorities about what in practice their policy procurements are actually resulting in. And that, I think, will add to the chance of successfully challenging the way local authorities are purportedly complying with 208, because challenging the policies can, just on the face of them, can be difficult. That's what I wanted to add. Thank you very much.
Thanks so much, Kevin. That was a really valuable contribution, really helpful. Great. So I can't see any more questions unless anyone's got something that they want to raise now. But I can't see that anyone wants to do so. I will just say thank you very much to everyone who asked the question of those really interesting contributions to the discussion. Thank you very much to our speakers, Matt and Connor, for two really helpful, interesting presentations. There are a lot of work to prepare and present, and yes, thank you very much for doing that. And thank you everyone for coming, and enjoy the rest of your evening.